docket number 20-207, Davis versus Benson, and 20-208, Lambert et al. Versus Benson et al. Do we have everybody here? I don't see Mr. Davis, but it might be, oh, there he is. Okay, everybody else here? Why don't you put your appearances on the record, starting with the plaintiff's counsels?
Good afternoon, Your Honor. May it please this honorable court, Robert Davis, pro se plaintiff.
Steve Doolin here for Michigan Coalition for Responsible Gun Owners.
James Makowski here on behalf of Michigan Gun Owners Incorporated.
Harry Johnson, co-counsel on Michigan Open Carry.
Good afternoon, Your Honor. Dean Greenblatt appearing on behalf of Thomas Lambert and Michigan Open Carry, co-counsel with Terry Johnson.
Okay. And then for defendants, we have Ms. Sherman.
And Sherman here on, yes.
Yeah.
And
the
Heather Meingas.
Busiest lawyer in the state of Michigan, Heather Meingas. Hopefully for not too much longer, though. And by that, I mean no more cases. Thank you for all appearing on this. As you know, or at least some of you know, I don't usually have arguments on these types of motions because the facts are undisputed and they're just legal issues, and the briefs usually resolve them, and the parties agree to that. But I had a few questions that I wanted to get to on this case. And I want the focus to be, which I think is primarily the focus in the briefs, on the APA and whether this directive should have been promulgated as a rule. It's somewhat straightforward, and you all did a very nice job briefing the issues and filing a few motions to file longer briefs, all of which have been granted. So I guess what I'd like to do is give plaintiffs an opportunity to do a very quick synopsis of their position, again, focusing on the APA issue and the standards for a preliminary injunction if you want to. And then we'll turn to defendants and see what they have to say. And I have more questions for them than I do for the plaintiffs. So Mr. Davis, unless have the plaintiffs' counsel spoken ahead of time to see about how they wanted to approach this? No? Okay, well, Mr. Davis, we'll give you 3 or 4 minutes, which I think is probably enough time to summarize your legal position, and then we'll allow other counsel to do the same, and then we'll, like I said, we'll turn it over to defendants. So, Mr. Davis, the floor is yours.
Thank you, Your Honor. Once again, Your Honor, thank you for this opportunity to present the arguments before the court, and I would like to thank the court for expediting consideration of the emergency motions in these consolidated cases. As you indicated, Your Honor, the issue is pretty straightforward. The written directive issued by the Secretary of State banning and prohibiting the carrying of a licensed firearm within 100 feet of a voting precinct constitutes a rule under the APA. In accordance with MCL 168.31 of Michigan election law, the Secretary of State is mandated and obligated to issue instructions and promulgate rules under the APA to provide proper direction to local clerks for the proper conducting of an election, which is, in this case, she did in the form of a written directive, directing local clerks to ban individuals from open carrying a firearm, a licensed firearm, within 100 feet of a voting precinct or a AV counting board. The case law is very clear, and the definition of a rule under the APA is very clear and unambiguous as well. It's undisputed that the Secretary of State is an agency as defined under the APA. It is undisputed that her written directive issued on October 16th to the local clerks is a rule as it is defined under the APA. And contrary to the Secretary's argument, Your Honor, the Michigan election law, being MCL 168.31, parent then 1, subsection A, is not permissive. It is mandatory. And thus, since it is mandatory and not permissive, the exemption cited by the Secretary in her response brief is simply not applicable, because the Michigan election law mandates that the Secretary of State issue written instructions and promulgate rules under the APA to provide guidance to local clerks. The case cited in my reply brief, Your Honor, is directly on point, which clearly underscores and illustrates the fact that the exemption cited by the Secretary is inapplicable because the mandate is mandatory and not permissive. So, Your Honor, I believe that it's quite clear that the exemption set forth under MTL 24.207J of the APA is inapplicable due to the mandatory provisions of Michigan election law. And as cited by Smith versus Department of Human Services 297 Mich. App 148, a mandatory action does not fall within the exception set forth in MTL 24.207. Therefore, Your Honor, it's quite clear that the written directive is a rule as defined under the APA, and the Secretary of State was required to promulgate said written directive as a rule, and it's undisputed that that did not occur. And so, Your Honor, a declaratory judgment is proper and necessary in order for the court to declare that her written directive is void and unenforceable.
Well, I don't know if I have to go that far right now, but I get your point. Who's going to argue for Michigan open carry, Mr. Greenblatt or Mr. Johnson?
If I could go first, Your Honor, and I would point out that Mr. Johnson, I don't believe, has entered an appearance for Mr. Lambert, but in any case, for Michigan open carry, Dean Greenblatt, thank you for the opportunity to present an oral argument in this case, Your Honor. I think it is deserving of it. It's sufficiently broad subject matter, but the issues that are raised are fairly simple. And I believe that Mr. Davis has correctly stated the analysis for a statutory permissive exception.
But Mr. Greenblatt, can I ask you a question? Do you read the directive as impacting individuals who have a concealed weapons license or permit, whatever they're called?
Well, yeah, and I'd like to talk about that because there are three classifications of voters that are directly impacted by the Secretary's pronouncement. We're calling it pronouncement, whether it's a rule, an edict, a regulation, a directive or order. It's been called everything by everybody. But I think that adds to because there's the confusion of what it actually is. But the three classifications of people are CPL holders who would go to a poll at a school, because they can only open carry in those instances. The second classification is CPL holders at churches if they do not have the express permission to concealed carry by the presiding officer of the church. And churches and schools are quite common in this state as locations for polls. The third classification are those that do not have CPL, concealed pistol licenses, and must carry openly in order to carry at all. And those are at locations that are not listed in 234D or 237A. They wouldn't apply necessarily to schools. They could apply to churches with permission. And it certainly would apply to government offices and things like that. So those are the three classifications. So to answer your question, does it affect CPL holders? The answer is yes, because there are locations where only CPL holders can carry openly.
Yeah, but they're carrying because individuals have, and I know the state will argue somewhat to the contrary, but I think the AG's already somewhat spoken on the issue. But they're going to argue that, well, I guess the point is the right to open carry, to the extent it's a right, exists irrespective of whether you have a CPL.
Yes, however, there are specific circumstances carved out in a reading of 237A and 425O, where the two read combined in peri materia is an express permission, and this is spelled out in our brief. It's an express permission for CPL holders to openly carry in specific circumstances. An exception to an express prohibition is permission under Builders Association.
Okay. Well, I didn't mean to cut you off.
Oh, no, that's fine. Cut away. I'm surprised I'm able to stay awake through everything as we've been up since yesterday afternoon.
Well, you and me both, so,
Appreciate it. Appreciate it, Your Honor. The defendant's pronouncement also suggests that voters may simply leave their firearms in their cars. This was in the page 1 of the response brief addressing Mr. Lambert. If Mr. Lambert wants to go vote, he can just drive his car to a polling place and leave his firearm in the car. Well, this statement presumes much, but it doesn't address the sole and fundamental issues at play in this case. And that is, does the Secretary of State have the constitutional or statutory power to regulate the behavior of voters? And the answer is no. 168.31 tells us everything we need to know about the powers and duties of the Secretary of State. And those duties include, the Secretary of State shall, under 168.31, issue instructions, promulgate rules pursuant to the APA, advise and direct local officials, publish instructions in a manual for assisting voters, publish pamphlets, prescribe forms, prepare ballots, require reports. There's about 13 different duties that the Secretary is commanded by statute to perform. What is missing here is the Secretary's duty to issue firearm restrictions on Election Day. And to be clear, this case is not about the fragile state of mind of 21 voters and what the Secretary envisions as the appropriate level of wokeness by voters. It's the question of raw abuse and assumption of power not authorized by law. And that's where we get into the purpose of the APA. The purpose of the APA spells out a requirement for agencies to submit their proposed rules to the legislature. For an obvious reason. It's the legislature that has the constitutional authority for time, place, and manner restrictions having to do with elections. I know I'm just answering your initial question, but if I can finish up, I have just another minute or so.
That's fine.
So this is a matter that cries out for declaratory relief and a preliminary injunction. Every day, there's another news story and a new interpretation of the legality of this pronouncement. Although all prosecuting attorneys and law enforcement agencies that have weighed in so far have agreed that the Secretary of State has overstepped. We have the prosecuting attorney at Kent County.
That's irrelevant. I mean, do you think that makes a difference in how I'm going to make a decision?
Well, no, but I think what it's important is that what we have here is a patchwork of interpretations. Because
yeah, and you're going to have a decision today, so that will be resolved.
Fair enough.
No more patchwork until the Court of Appeals does something.
Okay, fair enough. If determined that the Secretary of State can promulgate such rules, then she will not have any cognizable limit to expansion. Why not a statewide ban on open carry on election day? After all, people are carrying their absentee ballots to the polls, and we see from these statements that are, there's one affidavit that's notarized, the rest are not, some are not signed. Quite a few of the people have already voted. I'm not sure what those statements are supposed to do. It doesn't really address the issue about the raw power being exercised here.
Okay, Mr. Greenblatt, you said a minute or two, and you're probably surpassing that. Any last words on the APA?
Not on the APA, Your Honor.
Okay, well, that's what I'm going to focus on, as I indicated at the start of the hearing. Mr. Johnson, do you have anything else to say on behalf of Michigan Open Carry?
No, Your Honor. I believe Mr. Greenblatt summed it up perfectly, Your Honor.
Okay, thank you. We'll go to Mr. Mikowski on behalf of the Michigan Gun Owners, Inc.
Your Honor, Mr. Greenblatt has summarized the position with regard to the APA quite admirably. The only thing I would like to add in or note is that there's an enforcement problem here too. As you are well aware, there's a statute that says that voters should be free from arrest for misdemeanors or there's a breach of the peace. The only enforcement provision that's available to law enforcement would be to characterize the open carry of a firearm in and of itself as a breach of the peace. And I don't think that is anywhere recognized as something that can happen under state law. So,
hey, Mr. Mikowski, do you have the cite to that statute? I know I saw it in one of the briefs, but do you have that right on hand or no?
I will have it in just a second, Your Honor.
Your Honor, it's 600.1825. Para
Okay.
1.
Thank you. Sorry to interrupt, Mr. Mikowski.
That's okay, Your Honor. It said the statute says that voters are free to travel to and from the polling places without fear of arrest, except if they commit treason or a breach of the peace. If the enforcement mechanism going to be the open carry of a firearm is somehow a breach of the peace, that is a whole new standard that's not recognized under any authority whatsoever. The mere open carry of a firearm is not a breach of the peace. And that's also reflected in the Attorney General's opinion regarding open carry. It was issued some time ago by former Governor Granholm. That's all I have, Your Honor. Thank you.
Okay, Mr. Mikowski, thank you. And then Mr. Dulon, is that how I pronounce it, Dulon?
You're muted, Steve.
It's Doolin, Your Honor.
Dulon, I'm sorry.
That's fine. I'm here on behalf of Michigan Coalition for Responsible Gun Owners. And, frankly, most of our members are not open carriers, but what they're concerned about specifically is the bypassing of the normal procedure for making such rules and laws, and the demonization of gun owners in general by somehow determining that the mere presence of a firearm is going to be an issue with intimidation or assault or whatever it is that they're trying to say on the other side. But the other thing that's fascinating as I've dug into this over the past several days is that the justification for evading the APA all hinges on that subsection J that gives some leeway to the secretary regarding whether to use or not use the secretary's power. But that presupposes that there is a lawful power to make a decision about whether to use or not to use. It can't be that subsection J cannot be another path, an alternate path for the secretary to do whatever the secretary chooses, and to go beyond the administrative function of the job. And as was noted previously, I won't belabor it. There's a whole laundry list of tasks that the Secretary of State is supposed to see to, and they are all administrative. None of them have anything to do with some sort of a police power to control the behavior of voters beyond the mere logistics of where to walk in the building and which ballots to put where. Everything there is administrative, but we've got this seizing of some sort of a quasi police power by using a subsection that, as near as I can tell, is really just meant to be a shield against mandamus actions if the secretary chooses to not exercise some power that the secretary has. And that's a thin cloak, is the best way I can describe it, Your Honor. So therefore, with regard to the restraining order, the injunction, we do have a likelihood of success on the merits, and there certainly will be an injustice because there's already been damage done to Michigan's comprehensive scheme of gun law. One of the nice things about being a gun owner in Michigan versus one of those home rule states is we know what the law is once we learn Michigan law. And it's complex, but at least it's consistent across the state. And now we've got this being called into question. You've got literally millions of gun owners out there who aren't sure exactly what the rules are. We do, Mr. Greenblatt mentioned the Kent County prosecutor as an example, but these conflicting statements flying around in the press are certainly relevant to the need for consistency and clarity as soon as possible.
Okay. Well, thank you. And I will turn it over to Ms. Sherman and Ms. Meingast. Who's going to do what?
I am arguing, Your Honor.
Okay, then the floor is yours.
Well, Your Honor, I'm just going to adjust my screen really quick. To be sensitive to everyone's time and in light of the fact that we filed very, I would say, full and comprehensive briefs.
Well, can I ask you a few questions then?
Yeah, I'm happy to answer questions.
First of all, is there a statutory definition of polling places? I kind of assume there's not, but okay.
The best you can get is the MCL 168662, which provides for the local governments have to choose them, and they have to be in a precinct, and they have to be in a government type of building or a nonprofit building.
Well, here's one of my primary concerns. The directive, which is what I've been calling it, I think, anyway, the directive seems to, if you have, I don't know all, that's why I asked the first question. Where I vote in a school, okay? But I think it's a safe assumption that some people vote in recreation centers, churches, things of that nature. If let's use the recreation center example. I'm allowed, if I were a gun owner and I wanted to carry my handgun on my belt, and I could walk into a recreation center doing that under 750.234D or whatever that statute is, including if it's a polling place. But now under the series directive, I cannot do that. And that smacks of an attempt at legislation, and it certainly smacks of being a rule with substantive law that is going to be enforced, according to the directive itself, by the state police and other local law enforcement officials. And, I've looked at all the cases that everybody cited and more, and I'm having a very hard time buying that exception applies at all to this case.
Which exception do you mean, Your Honor?
The one you're relying on, J.
The permissive statutory power.
Yeah.
I'm sorry, what did you say, Ms. Meingast? What power?
The permissive statutory power exception. And is your...
If you stay close to how you lean forward like that, I can hear you.
Go like this. Okay. Well, Your Honor, is your concern that it's the substance of the directive or the...
My concern is that I believe this is a rule for the reasons I stated, and then your argument is, well, no, it's not because of this subsection J with the permissive language. But the cases that you rely on, when the courts have found that that exception applies, it's been a very specific grant of authority for the DHS to provide aid to dependent children or things like that. There's a lot of DHS cases, and here you're relying on a very general statement that the secretary shall issue instructions and rules pursuant to the APA regarding elections. I mean, if that is enough to exempt the secretary from the APA requirements, she could do absolutely anything regarding elections and not have to comply with the APA.
Right. The legislature chose to give her the option of issuing instructions or promulgating rules. That was the legislature's choice, to give her the options of doing these things. And it's not that she can choose to do one or the other, and the content or the substance of all those would be unrestricted. We would still be within the restriction that whatever we enact or whatever we promulgate or whatever we issue has to be within the election law or the Constitution. I mean, it's not an unrestricted authority. And the legislature has given, as we read it, Section 31A, issue instructions and promulgate rules. We have the authority to issue instructions, to promulgate rules for the enforcement interpretation of all of our election laws. That's what that means.
Does that provision, do you read that provision to also require that any rule or instruction, I think is the other term, it has to be in accordance with Michigan law?
Yes, we would agree with that, in accordance with law.
So if you have a rule or a directive that is inconsistent with another statute, it's not in accordance with the law.
I would agree with that, but there's no inconsistency here, Your Honor.
How is it not inconsistent, at least partially inconsistent with 750.234D?
Because there's no inconsistency here, Your Honor, whether you're a concealed pistol license holder or simply open carrying, because there is no affirmative right to open carry in all places at all times, right? There's still, the right here is still an inference from the lack of a prohibition. So there isn't an affirmative right.
But there is the more important point than whether there's an actual right, which, just this year, the Attorney General certainly made the strong implication that there was one. But the more important point is that the legislature has said, here are the places you cannot carry a weapon. And as I started off, I think in the beginning with your questioning, the secretary has expanded that. And so how is that in accordance with state law? I mean, if she wanted to give a directive to let the local election officials know where people cannot open carry, she should have just outlined the statutory provisions and called it a day. But she went beyond that.
Right, but there's space within, because there is no, you're still reading this as an affirmative right. What there is a lack of a prohibition, a criminality, a criminal provision to carry in certain places. That doesn't give someone the affirmative right to carry in all non-excluded places from the list, right? So there is a space, there is a void within which the secretary has exercised her authority that we think falls naturally under the Constitution, under our election laws, to provide for safety and security of voters and election officials and polling places. It's it's no different than the school districts at issue in the recent Supreme Court case, right? It's the same principles. We're not preempted from issuing a regulation. We can step into a gap or a void, just as the Supreme Court has done with respect to the concealed carry and open carry weapons in the courts. There's a space for us within we can regulate, because there is no prohibition or no conflicting statutory provision in this respect. So there isn't a conflict where our directive doesn't conflict with the actual statutory language with how it reads and the exceptions, there is a space within which we have exercised authority to protect and to promote the right to vote for all voters in all polling locations, all clerk offices, all AV county boards.
But do you see why? But do you see why then this goes back to the real question, which is whether this is a rule? Because think of what we're talking about here. We're talking about whether this directive conflicts with a state statute. It talks about whether there's a right to open carry in this state, and this affects everybody in this state. And when you look at the cases under the APA, they all talk about this. If it has general application, deals with substantive law, these are the things that are required to go through the APA, especially because when the legislature has spoken on this subject matter, even given if it's only partially spoken on it, the whole purpose of the APA is to allow. What was that?
You kind of went out a little bit. I'm sorry.
No, anyway. I'm sorry, I'm probably leaning too far back. It goes to this is not just a directive on existing law, and this is the kind of thing where public input is required. And especially, I mean, when you talk about the other thing that is concerning with respect to the other preliminary injunction matter or factors is there's already state law that prohibits voter intimidation. Right? So I mean, if anyone feels intimidated by someone brandishing or carrying an open weapon, then there's already statutory authority to take care of that problem, right?
That's correct, Your Honor. But then you're saying that there's nothing that the Secretary can do in advance to protect voters from even having to experience that situation and that discomfort.
Sure,
and that's the problem here.
There's following the APA or even the emergency procedures under the APA that the Secretary just didn't do this in the right way in the right time. They could have done this months ago.
Well, with all due respect, Your Honor, the need for this directive wasn't apparent months ago. As we set forth in our brief, the need for this instruction, for something to happen quickly, has grown over the last several weeks. It's with respect to the kidnap plot. It's with respect to the rhetoric.
That's why you have a state statute in place already. But anyway, I do understand. With all due
respect, Your Honor.
Yeah, go ahead.
I would simply point out, it seems that Your Honor is convinced that this is a rule, but remember, the exception to a rule is for the permissive statutory power. In other words, we don't have to promulgate something as a rule if we fall into that exception. And as I think we've explained adequately in our brief, and the case law is on point and helpful, that we are within the permissive statutory power exception. The legislature has given us power that is not tied to rulemaking, the power to issue instructions that is not tied to the and promulgate rules part. There are two separate activities that the legislature has empowered her to do under Section 31. It's not issue instructions and promulgate rules tied together. It's issue instructions or promulgate rules.
Well, it says
there are two activities. It is an and, it functions as an and in this case, and an or, right? Because what the legislature contemplates is that we shall do both, right? You shall issue instructions and you shall promulgate rules, but it's an or in the sense that you can do either. She can issue instructions, which is not tied to the APA, or she can choose to promulgate a rule. Could she have chosen to promulgate a rule here with respect to this directive? Sure, if we had thought about this 6 months ago, 8 months ago, a year ago. That's not what happened here, but that's okay because we have the issue instructions aspect, which I think is specifically designed for scenarios like this. The election law is fluid, it is very complicated. Things happen all the time that we aren't quite ready for. There's not a statute on, there's not a guidance on. We might be flying by the seat of our pants and issuing instructions and directives on election day. So that's the issuing instructions. If we were tied to rulemaking, we would grind to a halt. And I can tell you, every instruction that we have issued already was supposed to be promulgated, the election manual that we've had, that's dozens of pages, would fall apart. We
Well,
routinely issue instructions.
does everything in your instruction manual also address an issue that's been addressed by the legislature with a specific statute? I mean, I think that's part of the main problem here, is that the legislature has spoken about where you cannot open carry, and now the secretary is speaking on that same subject. That's what I think, unless everything in the manual also is dealt with in some detail by the legislature, which I kind of doubt.
Well, I think, Your Honor, is not, I mean, to me, this situation is on point with the recent Supreme Court case in Michigan gun owners. It's just like the school districts, right? Who have the authority to preclude, right? Because they were not a governmental unit subject to preemption. The school districts can adopt their own policies. They can preclude open carry as well as concealed carry on school grounds, or the open carry by concealed pistol holders on school grounds. And it's the same principles at work here. And so obviously the same principle sort of at work as the Supreme Court's issuance of its administrative order, which doesn't cite any authority to prohibit concealed carry, which it does. So, I mean, there is the state is not caught by sort of this preemption aspect, and this concealed pistol license, the firearm statutes do not address. Again, we're talking about an inference that there's a right to carry everywhere else because there's not a prohibition. Well, silence does not create a right.
No, but Attorney General Nussel, in her opinion on the Capitol Commission, recognizes that there is this, I don't think she called it a right, but the fact that—
She did not.
Right.
It's a concept of open carry.
Right. Well, I mean, look, if I'm walking down the street carrying a gun openly, I'm not going to get arrested, am I?
Depends on what you're doing with it.
If I'm just walking
where you are,
and it's on my side, I'm not going to get arrested.
If you're not in a place, right, if you're not in a place that prohibits open carry.
Which means that people can do it. And so that's why they have the prohibition in the statute.
It means they can do it until there's a prohibition that they can't do it. And we have stepped in to create a prohibition, which we can do.
Okay. All right. Well, anything else, Mr. Meingast?
No, Your Honor. I mean, for the reasons we've already articulated, we think that the request for injunctive relief should be denied. We think that we've demonstrated that the plaintiffs have not demonstrated irreparable harm. They have really no right here at interest that's implicated by this directive. And we have shown on the public interest and the harm to the other factors that there are numerous voters. We've had numerous complaints. There are voters who are afraid. There are election workers who are afraid to go to work on election day at their polling locations, at their AV counting boards. We have more than surpassed the plaintiffs on this point on the injunction factors that weigh in our favor, the public interest and the balance of harms. So we would ask that the court deny the request for injunctive relief.
All right, thank you very much. Do any of the plaintiffs' counsel want to have a brief rebuttal, or are you satisfied with the presentation already? Mr. Greenblatt?
Thank you, Your Honor. This issue about the Michigan Supreme Court case involving carry in schools was brought up in the briefs, the responsive brief by the defendants. It was brought up in our reply in response to that. It's been brought up again here in oral argument. And I need to make the point that the Supreme Court did not rule as suggested in the school cases on the issue of conflict preemption. As a matter of fact, they specifically indicated that they would not rule on the issue of conflict preemption. That is the issue here, is that the regulation, the rule promulgated by the Secretary of State is in direct conflict. It is conflict.
Well, but I think Ms. Meingast's point is that under that Supreme Court case, the legislature had not included school districts in the definition of a local government. So their silence allowed the school district to promulgate what they wanted. And her argument here is that the silence on any polling places or any other locations in the statute allows the secretary some wiggle room, so to speak, or the same discretion as the school district had in that other case.
In fairness, Your Honor, the Supreme Court indicated in the decision, in the opinion, specifically Stephen Markman's dissent, is that there exists a conflict with state law, very similar, virtually identical to the conflict that exists in this case, but that they were not going to rule on it. And the entire Supreme Court, in their opinion, chose not to rule on the issue of conflict preemption.
I agree.
That's the issue at case in this point. So I'm making the point that the Supreme Court in the school cases have not touched this. So it's inappropriate, I believe, to raise that case in the briefs. And again, here at oral argument when they didn't come to a conclusion on conflict preemption.
Okay. Any of the other for counsel? Mr. Deland?
Doolin, Your Honor, thanks. I'll be very brief. It's fine. I'll be very brief. I believe that near the end of her presentation, Ms. Meingast kind of made our point with regard to a very big picture issue, which is the fact that this is an area that is controversial. It's a matter of public policy debate for a long period of time, generations actually, and opinions differ. So she mentioned that there are some folks who are especially sensitive and have concerns. And then there are other people who say that it's pistol-free zones, so-called, or gun-free zones that actually create danger. And there's a bunch of data on that side of it. And I won't engage in that debate here and now, but I will point out that there is a public policy debate, that the proper forum is the legislature, not a single elected official making a last-minute decision.
Okay, thank you. Mr. Johnson, Davis, or Makowski, anyone else have anything else to add?
No, Your Honor. I think all of the things I wanted to say, I believe this court has asked and said, so thank you.
Okay, thank you, Mr. Johnson.
Likewise, Your Honor.
All right. Mr.
Agreed,
Davis?
Your Honor.
I'm sorry?
Agreed, Your Honor.
Okay. All right, well, thank you for your time. I appreciate it. Your briefs were very helpful. It's an interesting issue. I've spent a lot of time on it as well, and hopefully enough to get a good answer out to you. And I will have an answer to you as before 5 o'clock today. Okay?
Thank you,
Thank
Your
you.
Honor.
Thank you, Your Honor.
Thank you, Your Honor.
All right. Thank you.
Staff, have a great day.